Long Island Backstory with Chief Correspondent Gary Jacobs.
Hello, everybody. Welcome to another edition of Long Island Backstory. I think this is our 121st episode of Long Island Backstory. My guest today is a repeat guest, and as many of you know from watching the show, we don't do too many repeat guests. So if you're asked to come back on the show, that means you were a damn good guest or you paid me a lot of money. But since nobody's paid me any money, this is a good guest. And actually, besides getting a lot of views on the YouTube and a lot of requests for the show, I got so many people. I was literally inundated with people after the show asking me how they can reach Chris. And as I said to him before, he said he's not on Facebook. So I asked him if he was American because I don't know who's not on Facebook this day. But he was hard to reach, and he actually was kind enough to tell me if somebody called, though, and was in need of help, that I could give him his cell phone. So today on the show, at the end, we're going to talk about how people can reach him. So a little bit of background. As I said, our guest today is Chris Henry. This is his second appearance on Long Island Backstory. After we did this show the first time, so now I'm repeating because I started to try to ad-lib, now I'm reading it. But anyway, we're going to skip to the little background. Chris has a career in finance where he worked for several of the major institutions on Wall Street for approximately 12 years. He's a subject matter expert on finance and taxes for the IRS and the state of New York. Chris filed for divorce in Manhattan about 11 years ago, and this is where his story began, where he suffered the nightmare of the family court and the child support collection unit. As a result of his experiences with the court and child support, he filed lawsuits in the Southern District of New York, Manhattan. He filed 2 lawsuits against Judge Tandra Dawson of the Supreme Court and support Magistrate Paul Ryneski of the New York State and the New York State itself. He sued under the category Title 42 U.S.C. 1983 Act for conspiracy and fraud under the Social Security Administration Title 4D. So I guess at the beginning, the first question is going to be, because everyone was like, wow, good for this guy going. And a lot of people said to me, this guy is great. He makes a great case. Does he know what he's talking about, or is he full of shit? And my answer was, no, he's very smart. He learned a lot, and he's 100% right. But it's not going to go anywhere so easily. It's not a slam dunk because the system is stacked against you. Obviously, if people like Chris Henry won, the whole system would implode on itself. And it's not a fair game. You know, there's no justice when you go to these courts. This is all one big old boys club that you're going after. But as I said on the last show, if you don't file a lawsuit and you don't file motions and you don't fight back, I will guarantee you that you're going to lose. Guarantee you. So at least if you try, you have a shot of winning. I personally play lotto. I know there's a slim chance I'm going to win, but I still play it. Number one, somebody has to win, right? Because somebody always does win. And number two, I feel good knowing, you know, you dream about, you know what, if I win, and it's good for your mental state, saying that at least I'm doing something, fighting back. If it doesn't help me, maybe it'll help somebody else. And like I said, somebody has to win. The appellate courts are a fucking joke here on Long Island. The second department is a division of the Supreme Court. They're a joke. Our federal courts on Long Island are a joke. All they do is protect the lower courts. So it's not real justice, but they can't rule against everybody every time. Somebody at some point, they throw you, I say they throw you a bone, because that's I'm in the pet business, you know. But for lack of a better term, they do throw you a bone once in a while, and they'll give you a little bit of a win. Somebody, you know, listen, there's case law sometimes that we can use. So enough about me talking. I'm going to get into all this stuff because even since the last time, which is about a year ago, you also educated yourself even more. You're constantly learning. So I want to really talk about what you've learned that could help other people learn from your mistakes, and what they can do to possibly ride your coattails, for lack of a better term. So Chris, welcome back to Long Island Backstory.
Thanks, Gary, and thanks for having me again.
So let's just talk about the beginning, and just to get this out of the way, what is the status of the lawsuits that you spoke about last time you were on the show?
The status of the lawsuit is that they're saying they do not have jurisdictions because of what's called the Domestic Relations Law and Rooker-Feldman. It is a standard answer they provide to every case.
Standard. I think they had the letter typed up already, because everybody,
they do.
The wording is the same in everybody's document. No matter what they wrote, they write, throwing out on Rooker-Feldman, and they give their whole case law that's a rubber stamp.
Right, and also in the Rooker-Feldman, I write, as part of my complaint, an actual memorandum of law to prove that this is not a Rooker-Feldman case, this is a fraud case.
So you tried to preempt what you knew.
I tried to, but they still...
Explain to the viewers what Rooker-Feldman is. Just so
Rooker-Feldman basically says that if there's a decision in the lower court and it has been final, you cannot bring that to the higher court. That's actually a Second Circuit Court of Appeals decision, and everyone uses in all the districts. So it's called the Rooker-Feldman. To circumvent that, a fraud case basically circumvents that.
And they should accept the jurisdiction, but this is their way of not dealing with the issue. They throw it out and they say, you know what, I'm sure they know they're not right.
They know they're not right.
But they say, what's this idiot going to do? Take it up to a higher court? He's going to run out of money. The higher courts only hear what percentage? It's like a minuscule percentage, right, that they even hear?
The actual United States Supreme Court reviews less than 1%
Less than one, okay. Yeah, I was thinking too. So they go, this guy's dead in the water. He's not going to...
And they take 7 years to review cases.
Right. So that's their way of... which is not right, but that's just the reality.
However, if you file what is called a Rule 60, Part 4, you can bring the case back into district court, which is what I have done, which is basically rule on what is called a federal question.
Right, which there's just recently case law, I don't know if you want to talk about that now, where the district court was doing the same thing and saying, well, we don't have subject matter jurisdiction either, so we're going to throw you out too. But there was just recently a case in New Jersey where the higher court said, no, you do have an obligation to hear these cases. So that's pretty timely for your case right now.
Yes, it's timely for every case that's filed. There's about 154 cases filed within the district court across the country regarding the child support agency and the federal. And they keep throwing it out based on jurisdictional question, domestic relations law, Rooker-Feldman.
Okay. So now I just wanted to get a little bit of background for the people who are watching who may be curious about what happened. Let's talk about some of the things that you've learned and you wanted to educate people when they're going into court. So the first thing you wanted to talk about is the acknowledgement of paternity. What do you mean by that?
Right. So let's start off with, we'll provide what the issues are and then the possible remedies that you could use. The acknowledgement of paternity is the form or agreement that the child support agency uses in order to get you to summons you to court. Now, last year in 2018, close to 1.4 million forms were signed, and the first time you're aware of that form is in the hospital. You're presented to with signing for what is called a paternity agreement. What that does, it locks you into the child support program. As you may not know, and every man watching this show should know this, you are all enrolled in the child support program, whether you have a case active or not. And that is 45 CFR 246.30. CFR stands for the Code of Federal Regulations. It clearly states in A, all men, it should be everyone, are enrolled in the program. A quick example, I signed up for the Selective Service at age 18. I've never served in the military, but I am in the Selective Service database. So that's how you get into the acknowledgement of paternity.
Okay, so now let's talk about what somebody does at the beginning when they get served their first summons to appear in family court. Sometimes people don't even know this is coming. You think everything's going good, or you just had a little bit of an argument with your wife,
right,
or I guess your husband. It works both ways. And all of a sudden you get a letter in the mail sometimes. This is the first time you know about something, and it's a letter from family court saying you are summoned to appear on such and such a date. And of course, please bring your net worth statement with you on your first appearance so we can exchange net worth statements.
Right.
What is the first thing that you do when you receive this?
As you know, the Child Support Agency is a separate agency from the state. And that's 45 CFR 301.1, a separate agency. You get the summons, which we all get, to summons to court because your spouse or your girlfriend decides to file custody as well as for child support. The reason why they can do that is because you're in the database. They already have established personal jurisdiction by you signing the agreement. Now, people have argued, is it a contract agreement? It doesn't matter. This allows them to do that. So when you get there, your first question is, you should be screaming jurisdiction, that you have no jurisdiction to bring me into court. And to match that, Family Court Law 513, the case is called Matthew versus Burns. Family court is a court of limited jurisdiction. Therefore, jurisdiction must appear on the record. That is, if you get this summons, if you are not screaming jurisdiction to start off, you've waived it.
So, but what happens if somebody goes, you don't have jurisdiction? What is the judge's response?
And the judge is going to tell you, well, we have jurisdiction because you walk into the building. Well, here's the problem. Let's take the game of chess versus checkers. They both use the same board. Are they the same game? They're not. So when you walk into the building, it doesn't give you jurisdiction. You have to establish it on the record. And as I said, Family Court Act 415 and 315, Matthew versus Burns is the case that says you must establish it on the record, which means you can't just say you have jurisdiction. That quasi-judge or whatever, support magistrate, must put it on the record. If that's not the case, then that's your green light to walk out the door.
So now discuss the purpose. You talk about the purpose of the child support being a separate agency, statute 45 CFR 300 series.
Right.
Talk about that because I don't even understand that myself.
Right.
So I want you to explain that.
So
to
by
everybody.
now we should all know that child support was created as a debt collection agency. Now how do you know this? Well, there were 3 Supreme Court cases. The first one is called Blessing versus Freestone. And in that decision, Justice O'Connor says clearly as the major decision that it has nothing to do with the child and the mother. It's just a measurement for the successful, what is called debt collection agency. The second case in the District Court in New York, Second Circuit, they ruled under Sage versus U.S. A child support debt is no different than a student loan, a car loan. It's just a debt collection. And if you think of it in any other way, you are wrong. And the third case is Holberg versus Holberg out of Minnesota, said the same thing. You are a separate agency under the administrative. You have nothing to do with the child or the mother, which is why support magistrate cannot decide custody or visitation.
Now but now the Child Support Enforcement Unit, they have 13 remedies that they can do to and I don't want to say entice, but force you into, I'm losing the word, but force you into paying your child support. In fact, I was in court one day when the judge said, they are more powerful than the IRS. The IRS is limited on what they can do. Child support has 13 things. I mean, we all know, removing the driver's license, taking away your passport, garnishing your pay, taking away your tax refund, taking away your professional license. There's 13 things they can do. So if they are just a regular debt collection agency, how do they have so much more power than any other regular debt collection agency, which really can't do anything except for report to the credit agencies that you didn't pay and you have bad credit? Why do they have so much more power?
Well, their authority comes from Congress, who created legislation under the Uniform Family Support Act. That's how the debt collection agency is operating. Now, we can take each of these problems and have remedies. So today, I really want to state the problems and some remedies. So let's start off with, why do they have so many power? Well, they're given that power by the legislator. They've decided that the child support agency has more power, not only greater than the IRS, but greater than any other agency there exists.
I don't want to say that, but it seems like it. So
they do. They have
such power. It's scary.
They
have no due process, which is even scarier.
The due process issue always comes up in every court case, the Supreme Court case. So we can start with any one of the remedies. Like right now in New York, one of the largest problem is the DMV, where you suspended your license. Now, the last time I was here, there was a case that was going through the courts that was finally decided on April 2nd, and that is New Jersey. New Jersey can no longer revoke your license as a result of a warrant for child support. In fact, they're giving back all the license. And that has worked in other states. Here's the problem. In New York, it doesn't seem to work that well.
Yeah.
However, I would say continue to push forward. But the decision in the case is called Kavadis versus New Jersey DMV. And what the judge ruled,
I think our viewers need to write that down because, as Chris said, at the time of this taping, it has not worked in New York. But New York, that's supposed to be the most progressive state, seems to be the last state when it comes to a lot of different giving people their rights back. And number one in probably violating our constitutional rights. But listen, enough people plug away at this. Eventually, it's going to hit. And as you and I spoke about, even if you don't, you want to be on the record.
Yes.
So that when eventually someone's going to have the money, you and I don't have the money to take this all the way up, but somebody will have the money, they'll take it higher up, and they'll agree with the Jersey decision, and you'll already have a step ahead because you had already been denied and you had already brought that forward. Otherwise, you're going to be way back in the line.
Right.
And if you don't file for this, you will not have your license. If you file it and lose, you still will not have your license.
Right.
So why not do it and get on the record? So write down the case that Chris just mentioned and bring that. I think you said, I thought that you would have to go to court and present that to the court, but you're saying you can go direct to DMV.
No, you don't. You don't. In the decision by Judge Mary Jacobs, the decision.
Smart woman.
Yeah, the decision she made was that DMV process has nothing to do with the child or the mother. Why are they involved in the child support program? Their argument before her was, well, we were given a mandate, again, the powerful child support agency tell us that we need to revoke it. Well, she said that's not true. The due process requirements should be in place, as well as not only if it should be in place, you must provide an attorney in order to defend against it. So as of April 2nd, she ruled that it's unconstitutional in New Jersey for the Department of Motor Vehicles to revoke your license regardless of a child support order, because the two has nothing to do with each other. And here's what the kicker. The DMV was making $17 million from the restoration of your license. None of that money, as she said, went to the child or the mother.
Now, you say this is against the Constitution. Is this against the New Jersey Constitution, state Constitution, or the U.S. Constitution?
It is against the U.S. Constitution, even though it's a decision in New Jersey. As you know, we have one court system in this country under 9 judges. That is, a decision in one circuit is valid and is recognized as full faith in all circuits. Of course, New York is saying they're not covered by this, but we have found that we've tried it in South Carolina, Illinois.
You just did in New Mexico.
And we just did it in New Mexico and Arizona. It works because, again, you go to the Department of Motor Vehicles, not the courts. The issue is you removed my license without due process, as the judge says, and you should have what is called a breathing room of at least 60 days, give the person opportunity to challenge it as well as response.
And get an attorney.
And
appointed.
And you must appoint an attorney on behalf of that person. So that's the best part of the case. And so most DMVs are saying, well, we don't want to provide you an attorney.
Give back your license.
And we'd just rather give you back your license because it's just a shortcut. And then if there's a multi-state order, we'll talk about what a multi-state child support order, then they really don't want to get involved because now they have to establish jurisdiction in those states in order to maintain revoking your license. Again, the average, they don't want to do it. So that's why the Kavadis case, to me, is the beginning of removing yourself from child support.
Okay, now let's talk about support magistrates, who are always a sore thumb because a lot of times they're really problem people, because these are people who sometimes they don't want to elect to be a judge because they know there's going to be issues, but for political reasons, they'll put them in as a support magistrate, and many times they don't move up to judge because they just know they're just bad lawyers. I've seen really bad experiences with support magistrates. Also, there's issues, again, with jurisdiction, whether they're a judge, what they can do, what they can't do. But talk about, you mentioned that you should highlight the deprivation of rights letter to the support magistrate who is not a judge.
Correct. So let's get, most of our problems with child support is the support magistrate.
Absolutely.
In New York, they are hired as lawyers for 3 years in family court. They're now saying they are judges. No, they are not. They're attorneys. Their specific hiring says they are attorneys.
And they let you call them Your Honor. They sit there acting like a judge, like in a Halloween costume. You know, with the court officers there treating them. When the judge comes in, you'll do this, you'll do that. So they put on a facade that the average person has no idea. They think they're a judge. You know, of course, they find out that they can't put them in jail, right?
Right.
And I was told, and for the people who are watching, I don't know if this is a fact, that they can't even hold you in contempt. So if the judge says, if you say this one more time, I'm going to hold you in contempt, they're not a judge, so they can't hold you in contempt of court.
Let's talk about that carefully, because what happens is many of these contempt orders, and again, I'm going to go back to the statute, Family Court Law 439A, for all the attorneys watching, you could start flipping your pages. It clearly states that a support magistrate cannot enforce a contempt, nor can they issue a contempt order. It happens all the time. Why is that? The separation of powers. They are not judges. They're attorneys. It clearly states they're hired as attorneys. Only a judge can issue a contempt order. So technically, the contempt order is an offer that you have to accept. So you have to rebut it. And I'll give you the case law. Lillian T. versus John T., Second Department, ruled the same way. A contempt order is not a true order unless confirmed by a judge. Bracio versus Bracio, same thing. In New York, I'm not quoting you federal cases, it's New York cases, they are not. So if you get a contempt order, if you're not screaming jurisdiction at the first onset, you should be screaming subject matter jurisdiction because you can't issue a contempt order, as well as rebut. What happens to many people is that they do not write a rebuttal order and quote these cases. If you want to call them Your Honor, you're welcome to do that, but you can say Mr. or Mrs., like in my case, Paul Ryneski. He is a false judge. He is, and again, at the time I didn't know it, but now I know he's a support magistrate. And therefore you can challenge them, and you challenge them on those issues.
No, you say refuse to cooperate. What do you mean by that?
Okay. Now,
I mean, you get a summons, you got to show up. You're gonna, if you don't, you're going to get a warrant for your arrest.
Right.
So show up. If you get a summons to appear in family court and you really do get it, show up to court.
Right.
Because there's going to be bad news otherwise.
And so let's walk through this. It's a very simple process. If you get a summons to show up for family court, please show up, or else you'll get a warrant for non-appearance.
Or they'll do an ex parte hearing,
An ex parte.
and you'll lose everything.
You get a default order.
Exactly.
Now, why do you show up? As I said before, all men are in the database for child support. If you've signed acknowledgement of paternity, you've given them personal jurisdiction. So the next step is your appearance. That is why you have to appear in court. And while you're there, you can challenge all you want, or in writing, but you have to appear, or else you'll get a default order, and then you have to work through the process of vacating a default order. So the second thing while you're there is, again, you can challenge their delegation of authority. They need to tell you, are they a judge or not?
So you're saying ask them, are you a judge, what is your authority?
You put that in writing. Prior to coming to court, you write a rebuttal letter. That's basically state you're appearing and you're asking for delegation of authority. If they say they don't have one, then they are not a judge. All Article 3 judges have delegation of authority, which says, I am a true judge.
So one of the things that you said you wanted to make sure we talk about, but I have no idea what the hell it was describe the testimonial.
The testimonial. Okay, testimonial is that you must rebut everything before a support magistrate.
In writing or on the record?
In writing. Okay,
So in what format? I mean, you write a letter, do you have to do an order to show cause?
This is outside of whether the instruments are petition, motions, or order to show cause. What it is either an affidavit or a memorandum of law, where you will state your rebuttal or objections to where you are. It is important that that precedes you, which is to serve everyone. But you can basically state why you object to this support hearing. Because you cannot go there, going there and arguing, they will shout you down, they will tell you that we
And they're intimidating, even though they're not a judge. You have court officers, and if they start, and I've heard, the court officer will tell you, stop, don't talk anymore.
Right.
And you're done. What are you going to do? You're not going to get tased.
So let your document precede you, because you can always say.
And you can mention it too in court.
Well, you have to. Remember, a petition before the court, any court, must be answered. Must be. So you can say, Your Honor or Mr., I've put a rebuttal in for this hearing. I'd like for us to discuss that here. If they decide they cannot, everything you state in your testimony, which is really called an affidavit, stands as law. Which means if you put in there that I don't want to be in this hearing and they do not cover jurisdiction, then that's now become this testimony before the law.
Okay. Now let's talk about millennials and child support, because now, obviously the divorce rate is high, and many people get married, they still have their student loans, out there, and all these other bills out there. And that's how they get wrapped up where they just fall behind, not because they're bad people, because, the courts don't take all these things into consideration. And the law is that if you have an order from a court, it's presumed that you can pay the order, otherwise the judge or magistrate wouldn't have given you the order. So you're screwed because really a lot of times you can't. They impute income to people, they don't take into consideration things such as, student loans, a new marriage, your car payment, your, other commitments that you have to other financial institutions. And as well as I do, many people just can't afford to live with these things. So what do they do?
Right. So for millennials, for most of you who don't understand that millennials are the largest group in this country. It used to be the baby boomers at 76 million. It is now millennial at 87.1 million. On my YouTube channel, I talk about that. I have a YouTube channel called Child Support Made Simple. So I've simplified all these answers for you. So let's start off with millennials. Millennials are the group that has what is called the student debt of over $3 billion. That's your first debt. The income limit, what they call it, the consumer protection limit is 25%. But in the child support order, they write into the legislation that the child support payment supersedes not only the federal limit, but also student loan. So what's the first deduction from your check is child support, as high as 50%, and in New York, it's 65%. So think about this, do the math. If you take home pay after taxes, 65%, the max. Then you take out another 25%. A quick math is how much do you have left? 5-10%. Now, in New York, you cannot live in 5 and 10%. So if you're on student loan and you have a child support, you need to fight it and fight it hard and fight it every day. Because what happens is it supersedes every other debt. You have to fight it. You don't have a choice. Sitting home, oh, I have this. No, you have to. It is 65% of your paycheck.
Chris, we're running out of time, so I hate to cut you off, but I just want to get, isn't there a law that they can't put you below the poverty level, that they can't take enough to put you, because that's cruel and inhumane punishment, and they can't put somebody below the poverty, not that they don't do it every day of the week, but that's an argument that I've heard made, that you can't put me below the poverty level.
Well, the income withholding, which is the bread and butter for the child support program, which is the automatic, they cannot push you into the poverty level. But here's how they get around it. They impute the income and focus on what we think you potentially...
So they use that to say, well, even though he's only making this, we imputed him, so he should be making...
He should be making...
Wow, that's the way they get around it?
That's how they get around it, by saying, well,
scam.
You have a college degree, and based on the actuarial table, you should be earning X. Regardless of the economy, you should be earning X. So what happens is they get away with saying
that's how they get around.
Imputed income at 65%, student loan at 25%, and therefore you should make it. But what that does, it now leaves you in contempt of court.
Which is what they like.
That's
really the goal. I mean, at the end of the day, the goal is to put you in arrears so they get, which we talk about in another show, so they get more title for demunding, because the money is greater when it's called arrears.
Right.
It's great if they put you in jail, right? Because now the court officers, the sheriffs, the jails are filled. Everybody makes money on that situation. Maybe they'll give you a lawyer so he gets more money. The court, so everybody, that's a win-win for everybody except for you.
Right.
In fact, they could push the family into where now they're on welfare, which is great, because now we feed this welfare system and everybody's, that's...
And now here's what's real critical. The two debts that you cannot charge on your taxes are student loan and child support.
Great. Chris, in the last couple seconds, tell everybody where they can reach you.
They can reach me at my YouTube channel called Child Support Made Simple, as well as my email, which is chrish289@protonmail.com. And it will be down in the description as well.
Great, very good. Chris, thanks so much for coming on the show today. I'm Gary Jacobs. Thank you for joining us on Long Island Backstory. If you're watching this on TV, please go to our YouTube channel, Long Island Backstory, click subscribe, and you'll get notified every time we put a show on the air. Thank you, everybody, for joining us.
Long Island Backstory is made possible in part by Americans for Legal Reform, the oldest, most successful legal group in the world. P.O. Box 2679, Huntington Station, New York 11746. Telephone 631-421-6390. Website Americans4legalreform.com.